Irene Soto had been drawing courtrooms for 14 years. She had a freelance arrangement with 3 legal publications, and she worked in pastels and graphite, mostly graphite, because graphite caught the quality of light in the gallery that pastels didn't. She was particular about what she chose to draw. Most of the time the choice was made for her, the case that made the news, the sentencing that drew the cameras outside. But sometimes she chose, and when she chose the rooms that made her feel the weight of the work that was being done in them. She had been choosing Courtroom 9 for 2 weeks. The case was not newsworthy. It was never going to make any publication. Lester Garfield, 61, no prior record, armed service 1984 to 1992, medical technician with the 68th, 2 tours, honorable discharge. 17 years as a licensed EMT after that, until his wife's second round of treatment drained the savings and the part-time work he picked up. Afterward wasn't enough to keep the apartment. He had been living at the Varden Street Transitional Shelter for 4 months when he walked into the Broad Street Pharmacy and took a $6 sandwich and 2 bottles of water. The security camera showed him choosing the cheapest items on the shelf. He had $2.14s in his pocket. He had not tried to hide what he was doing. The public defender assigned to his case was a young woman named Cara Aldous. Second year, case number 43 on her docket that month. She was not overwhelmed in a way that showed, because she was the kind of person who does not let things show. But Irene could see it in the way she organized her materials and reorganized them and looked at the clock. She had done what she could with the time she had. The DA's office had filed for 30 days and a fine. Judge Miriam Tenley had been on the bench for 9 years. She was not famous, not given to speeches, not the kind of judge that court reporters wrote about because of the color of her language. What she was, in Irene's experience of watching her over 2 weeks, was a person who read the record, the actual record, not the summary. She had asked for materials in 3 previous cases that no one expected her to ask for, and had received them and had read them, and it had changed the outcome in 2 of the 3 cases in ways that the attorneys involved later described as unlikely. She read the record the way a person reads something they intend to be changed by. The Garfield case came up on a Tuesday. It was case 7 of 11 on the morning docket. Irene had her graphite out before it was called. The day presented the filing. 30 days of fine restitution. It was straightforward, he said. A clear-cut theft from a retail establishment. Security footage unambiguous. He said this in the professional tone of a man going through a process he had gone through many times, and did not find particularly notable. Judge Tenley had the file open in front of her. She had been reading it while he spoke, which Irene had seen her do before. She waited until the DA finished. Then she said, "I have a question before we proceed," he said. "Of course," she said. "The recommendation is for 30 days and a fine." "How much time did you spend with the full record before this filing?" he said. "The record is straightforward, Your Honor." "The theft is documented," she said. "I understand that. I'm asking about the full record. The service record, the EMT certification history, the medical expense documentation attached by the public defender. How much time did you spend with it?" A pause. He said, "We reviewed the essential facts of the charge," she said. "I see." She looked at the record in front of her. She said, "Mr. Garfield served for 8 years. He spent 17 years as a licensed EMT. His wife died 14 months ago. He has been at the Varden Street Transitional Shelter since March. On the day of the incident, he had $2.40. He took a $6 sandwich and 2 bottles of water. He did not run. He did not attempt to conceal. He chose the cheapest items on the shelf." She looked at the DA over the top of her reading glasses. She said, "I want to be precise about what the law permits me to do here, because that is my job. The law permits me to consider the circumstances of the offense. The law permits me to consider the defendant's history and character. The law permits me to consider diversion and non-custodial alternatives. None of that is discretion. All of it is the law. I am not departing from the law. I am applying it." The DA said, "Your Honor, the filing is consistent with standard office practice for retail theft." She said, "I know, I'm not criticizing your office's process. I'm telling you what the full record shows and what the law permits me to do with that information. Those are 2 different things." She turned to Lester Garfield, who had been sitting at the defense table with the stillness of a man who had learned very early in life that the most useful thing you could do in a difficult situation was stay still and wait for it to become clear. He was in a gray shirt and dark slacks that the Varden Street Shelter had provided for court appearances. He looked at the judge with the direct, unanxious attention of a man who has nothing to perform, she said, "Mr. Garfield, I've read your record. All of it." He said, "Yes, ma'am." She said, "I understand what happened and why." He said quietly, "I shouldn't have done it." She said, "I appreciate that. I also understand that you had $2.14 and had not eaten that morning." He said nothing to that. There was nothing to say. She said, "Here is what I'm going to do. I'm going to defer sentencing for 90 days, and I'm going to refer your case to the Aldworth County Veteran Services Program, which has a housing liaison that I understand you have not yet been connected with. I'm going to ask the public defender to follow up on that connection this week. I'm going to ask the DA's office to review the filing in light of the diversion guidelines for first-time, nonviolent, need-based offenses, which I think a careful review will show applies here. If you complete the program and maintain compliance, I will dismiss the charge. This is lawful. This is what the law permits. I want to be very clear that this is the law being applied correctly." The DA said, "Your Honor, with respect." She said, "With respect, counselor, I have read the full record. I would encourage you to do the same before the follow-up filing." A pause in the room. Irene was drawing without looking at her paper. The session moved on to the next case. Afterward, in the corridor outside courtroom 9, Irene stood at the window that looked out over the parking structure and thought about what she had just drawn. She had drawn Judge Tenley's face in the moment she asked the DA how much time he had spent with the full record. She had caught something in it, not anger, not sentiment, not performance. Something more precise than any of those things. A woman doing her job with the full measure of what the job required. The recognition that what was in the room was a person who had served his country, buried his wife, lost his apartment, and walked into a pharmacy and bought a sandwich because he was hungry and he had $2. The law permitted that to mean something. She had applied it. Irene labeled the drawing, Courtroom 9, Tuesday. She did not label it anything more specific than that. Some things didn't need more words than the room itself contained.